the amicus.
Thank you. Yes, Mr. Maniki.
As the court pleases. I propose to address 4 issues. The first is the question of the powers of the public protector and the status of her findings and remedial action. And in that regard, as you will have seen from our heads, we support the judgment of the High Court. And the second issue I wish to address, and on the basis that we support the High Court judgment, is the rational basis for rejecting the findings and remedial action of the public protector, and why the High Court in our submission ought not to have granted the order to, as it did, in respect of the institution of disciplinary action. Then the third issue I wish to address is the order of suspension, and we, in our respectful submission, we will wish to persuade the court that that order was inappropriate, and mainly for 2 reasons. Firstly, it was not part of the public protector's remedial action, but secondly, that it infringes the doctrine of separation of powers, and we've made other submissions in the heads which I might deal with also. Then the last point I will address is the appropriate order that this court may grant. Even if the court were to uphold the High Court order in respect of the institution of disciplinary proceedings, but were to uphold the appeal in respect of the order regarding the suspension.
Well, sorry, the one thing you don't deal with is the question of timing. Why are you here at this point in time? I mean, relief was sought in 2 parts, Part A, Part B. The High Court has yet to deal with Part B. So we're dealing with unterminated proceedings in the High Court, and yet here we are on appeal. So we end up in a situation where you have a proliferation of piecemeal hearings, a proliferation of piecemeal appeals, because in truth, it's entirely possible that that Part B may overtake what we are dealing with. So do you want to perhaps address that?
Yes. Justice Ponan, the manner in which the matter was pleaded in the High Court was to, in essence, to delink Part A to Part B. So Part A related purely to whether the public protector's recommendation in respect of discipline should be instituted. And the outcome of that is quite independent from what happens in Part B, because, if I may submit, even if the appointment is upheld in the High Court in respect of Part B, if this court were to uphold the order of the High Court in respect of the institution of disciplinary proceedings, that will take place.
No, but
because the question of conduct...
But Mr. Manichi, let's just step back for a bit. Let's say you were a puny judge. Let's deal with a notional puny judge, faced with a notice of motion in this matter. Let's just look at it, because...
Yes.
It may, and you may very seriously want to consider the first and second appellants, their position in relation to the first part, as my brother opponent put you, is in your favor in relation to over-breadth of relief. So
yes.
that is in your favor. But what I want you to just concentrate on is the Part A is the interim relief, because it's sought as on an interim basis. So you come for interim relief pending the conclusion of the review.
Yes.
Now, the review raises almost, it's the kitchen sink, isn't it? It's everything.
Yes.
The review will then decide whether he was rightly appointed, whether there was nepotism that's complained of, all of the other things. So that's what the review will decide.
Yes.
If the review, for example, were to decide that he had been wrongly appointed, well, that would be the end of the matter.
That is
if
correct.
we decide that he was rightly appointed, then it would go over to the other matters. So let's just stick with that for the moment. If Judge Skippers had considered that it was truly interim relief that had been asked for, that's all. Then, apart from the substantive issues, there was a lower threshold to cross, wasn't it? It would just be open to some doubt.
Yes.
So right open to some doubt. What he could then have said is, okay, pending the review, and the review is going to be accelerated because it affects the national broadcast, it affects everybody else. Pending that, we'll just suspend you. Wouldn't that have been the prudent thing to do? And I think the question that my brother asked, and that we're concerned about, is how did it morph into it being final relief?
Yes.
So in respect of the first and second appellate, as distinct, Mr. Aronson may have a different view on suspension with pay, but leave that aside. I don't know why it's against your client's interests and the interest of the second appellate that you don't abide that at the very least, because in that lower threshold, there'd be no argument. So that I think is what we're putting to you. Why are we now being asked to deal with matters that ought to be the subject of a review? And in the review, you'd have a full record, you'd have more documents that would be made available, and then the court could decide conclusively on what would happen. So how did this happen?
Well, as it turned out, initially it was interim relief, but when it was argued, the DA moved for final relief, and the court granted final relief. But the application was in truth an interim relief application. And as matters stand, the Part B application has been expedited. It will be heard on the 12th of October in the High Court, which I presume raises the issue that the court is raising with me.
When is it going to be heard?
On the 12th of October, 12th and 13th of October. The Part B is to be heard by the High Court.
Well, let me ask you pertinently.
Presumably you will be back, because presumably there will be an appeal in respect of that as well.
That's very possible, Justice Ponden.
Yes. But could I ask you, Mr. Maneche, and I'm going to ask you this pertinently because we're all concerned about it. Why would you not abide? I mean, why wouldn't it be in everyone's interest, including perhaps Mr. Aronson might give some thought to it, because I don't know that we would do it on the basis that he's not paid in the meantime, because it's in any event a short while. But on the lower threshold, if we found that what he was rightly confronted with, Skipper's jail, that he ought really just to have granted interim relief on the lower threshold, and the matter could then be resolved once and for all at a hearing on review. It would seem to me that that would suit everybody. We won't get into the substantive issues because the threshold is lower.
That would require me taking an instruction, Justice Nafsa, on the attitude of the first respondent and also the attitude of the second respondent in respect of the. Let me ask you then, as counsel, advising your client. Yes.
What's wrong with the proposition the three of us put to you, my brother presiding and Justice Ponnen and myself? What's wrong with those propositions?
What's wrong with the proposition, and that's the main submission we make in respect of the suspension relief, is that firstly, the suspension relief was not even part of what the public protector had taken as remedial action, firstly.
No, but I'm putting to you a different proposition. DA comes to court and says, look, here's the public protector's report.
Yes. It
says it raises all sorts of ugly things. Now let's accept that for the moment we can't conclude conclusively that they're as ugly as they say.
Yes.
But there's enough there to meet the lower threshold. So what he should have done is he should have considered that he was dealing with an interim relief, because that's how it was couched. And he should have considered that by deciding what he decided, he was preempting the review. Now, what's wrong with that notionally? That's all I'm putting to you. I'm not asking you anything else. I'm asking you what jurisprudentially is wrong, procedurally, technically, substantively is wrong with what we're putting to you.
We submit that the DA, in respect of suspension as an interim relief, had not made out a case for even open to some doubt.
Rightly or wrongly, we're now sitting with this case.
Yes.
If in fact the judge in the High Court had granted no more than a suspension on full pay, pending determination of Part B,
yes,
would you be here?
No, we wouldn't have been here, because that would have been not appealable as interim relief. I accept that.
Yes.
All I'm submitting is that we would, in this court, try to persuade this court also that even that part of the order shouldn't have been granted on an interim basis.
Well, okay, could I put a different question to you? Assuming that you're right in the argument, and they shouldn't even have granted that, well, that would be the end of the matter in your favor.
Yes.
But you accept that if we come to a contrary conclusion on the lower threshold, that the order that should then follow would be the one that we put to you?
That could be the order that follows if we find against us. In other words, we find that even though the SABC and the minister had not had occasion to consider whether to exercise the discretion whether to suspend or not, it was appropriate for the High Court to exercise that power itself.
Well, what I'm saying to you is, and I'm just thinking public interest here. I'm thinking about the public protector as a section, as Chapter 9 institution. I'm thinking about the ministry. I'm thinking about the SABC. Wouldn't it be better to have this matter, whatever the rights and wrongs are, decided conclusively by a court in the review application?
Yes, that we accept fully. The difference is simply whether there's a holding suspension in the meantime, and whether that is a matter that was made out, a case that was made out in the High Court.
Yes, I think we can proceed on that basis.
Should I proceed? So I will address the question of the topics as I pointed out. So the first relates to the powers of the public protector, and as I pointed out, we support the High Court judgment in that regard. We submit that the proper approach to determining the status of the public protector's findings and remedial action requires a proper characterization of our powers in terms of Section 182 of the Constitution, within the scheme of that section.
Could we find common ground, at least on this basis, in respect of powers?
Yes.
That comparatively, whether you're dealing with the European Union Ombud or whether you're dealing with Sweden or Denmark or Spain, that our legislation, the Public Protector Act, goes further, as does our Constitution. In terms of powers spelt out, remedial powers, you don't find those across the board.
No, our provisions in Section 82 are different.
They're unique.
They're unique. I accept
so,
that. They're not.
So
they're
it's a bit difficult to draw from other jurisdictions, because the nature of the institution is very different to what one finds elsewhere in the world.
What I can say is that it wouldn't completely be inappropriate to draw from experiences in other jurisdictions, but one would do it with caution. As the High Court said, one does that with caution because of the scheme of our Constitution in respect of the powers of the public protector. So we accept that in order to understand the nature of our findings and remedial action, one must start with the Constitution, can't start from comparisons with other jurisdictions.
Well,
that we accept.
Do you accept, though, that facially at least, there appears to be a contradiction in the judgment of the High Court? On the one hand, the judge in the High Court appears to suggest that the findings are not binding, and then he says they cannot be ignored.
Yes. This is how I try to reconcile that finding of the High Court and drawing some guidance from the Bradley judgment. It is that there are two ways in which one can look at whether the findings are binding.
Well, I don't want to cut you short, but
yes.
Is Bradley analogous? Is it?
Hi. Hello? Yes, I can hear you. I can hear you. I'm finding you. Okay. Yes, I can hear you. Yes, I can hear you. Yes. Okay. Okay. Isaqali.
Procedural. 4 minutes. Yeah, come on.
A very good morning to you, Elvis, and a very good morning to our viewers as well. Like you said, Elvis, well, indeed, Elvis, we are still outside the Supreme Court of Appeal here in Bloemfontein. I must indicate that people have come out in large numbers. You'd recall that there's also a group called Friends of Hlaudi Motsoeneng. They started together with Hlaudi Motsoeneng when his case started, whereby they were saying hands off Hlaudi Motsoeneng, and they continued by saying that he's got a good story to tell here at the SABC. But today, they hear saying that Hlaudi Motsoeneng has got 20 years of selfless service here here at the public broadcaster. So they are here in large numbers from the different provinces. I've spoken to some from the Western Cape, some from the Free State itself, some from Gauteng, the different provinces of the country. Like I said, I must indicate that we've also seen a few people coming in before the court proceedings started. We have seen the DA's Jane Self here as well. We've also seen the public protector herself here at the court today. But with me here is one of the people who came here to support Hlaudi Motsoeneng. He is from the Writers Association from the Vaal Triangle, and his name is Gift Moatludu, who's going to tell us a bit more as to why they're here as the association. Gift, a very good morning to you. Just kindly tell us, why are you here as Writers Association today?
We are here as from Vaal to support Mr. Hlaudi, and we are here to say that we should basically, they should have give him justice, because at the end of the day, if we will talk about like the results of the people that have been having like the education and whatnot in terms of the results, but we are seeing something different like in South Africa now. In SABC, we are seeing employment. Also, we can see like the change, because if you check SABC before was in debt. But as we speak now, we are talking a different thing. I mean, SABC, with his leadership, I mean, it has changed, and you can see that also in terms of language. We have all different languages that are given like the opportunity in terms of like SABC 1, SABC 2, and SABC 3. You can see different languages that have been used there, and also we are conscious of that. And we would say that with what is happening like now in South Africa, and to view what is happening like in South Africa, is because of his leadership. And we would like to say that the people like outside there, we should just give him a support. So far, I would not say that much, but to say that they should just leave him and continue with what he's doing now.
What specifically has Mr. Hlaudi Motsoeneng done for the writers in the country? Because you're talking about his successes.
Yeah. Okay, what happened was that the last time we had something that was happening like in Vaal, very big occasion that we had, and then we had different people from, in terms of Zulus, Sutus and all that, they were there. And we had a support from SABC, and also from him personally. He was there supporting like the occasion. And you would see that it is not all about whether somebody discrimination or anything, but what I would say that is that it's supporting like everybody, it's supporting like the youth, it's supporting the elders and all the people like in South Africa.
Well, that's Gift Moatludu from the Writers Association called Indlaganizo from the Vaal Triangle, saying that they came here in large numbers just to ensure they support the COO based on his contribution towards language development here in the country. Like he indicated, even gave an example when the COO attended one of their functions there in the Vaal Triangle. That's basically what is happening. But I must also indicate that the court proceedings have started as I talk to you now, so we are waiting eagerly to see what is likely to happen. But you would also recall that we are not likely to hear or know about the judgment today, because the Supreme Court of Appeal judgment takes between 6 to 8 weeks or 3 months at most. But for now, it's back to you in the studio.
Thank you so much, Palisa Chibisi. She is in Pretoria, and will probably cross live to the court case as soon as we can establish that link to the case. So stay tuned right here on Channel 404 AM News.
Or the minister in this case?
Yeah, well, I mean, in this case, for example, you've got this report after a fairly detailed investigation, pursuant to complaints that have been received. And then the report comes out. Nothing is done to challenge it.
Well, I'll answer that question and also deal with the question that Justice Nafsa posed to me. The application, in relation to the question asked by Justice Bonnen, the application in the High Court was brought at a point when the engagement with the public protector, between the public bodies and the public protector, had not been concluded yet.
No, but hold on. There are dates in the public protector's report. Yes. Sorry, in the affidavit filed by the public protector. I think it was the 14th of August that she deposes to the affidavit.
Yes.
I think there was an indication that by that period already extensions had been sought, extensions had been granted. She was under the impression that in fact the measures were going to be implemented. There had been an undertaking in Parliament, as I understand it, by the previous incumbent of the office of the Minister, Mr. Yunus Karim, to engage with and to implement the report. In the face of that, there is this meeting at which, lo and behold, the person who is very much at the heart of the report is then appointed permanently.
Yes, all I was answering Justice Ponen is that the final date, the deadline for the two public bodies to engage the public protector was the 16th or 17th of August, if memory serves.
17th of August.
Of August.
Yes.
But the application had already been launched by then. The public bodies had to respond in answering affidavits in the High Court as to what their attitude was to the public protector report. That, if it wasn't for the application, would have been done in an engagement with the public protector.
No, but if there was an endeavor to seriously engage, how is it possible for the permanent appointment to have been made?
But
I mean, how is that consistent with any engagement at all?
Well, as the Justice presiding, Justice Nafsa pointed out at the outset, that is what is the subject matter of the High Court Part B review. The point really is that the remedial action that the public protector has recommended is not precluded by the fact that he is appointed. As it is, the High Court order is that he be disciplined, despite the fact that he's been appointed in a permanent post. So
that,
you suggest that the public protector has an additional responsibility after taking remedial action of seeking intervention, suggesting that perhaps she has to go to court. Is that
no? That is.
Or seek intervention of the National Assembly in this case.
Well, yes. Can I answer this way? The question about going to court was answered in a sort of general question that was put to me, that one of the remedial actions that the public protector may take is to go to court, which is we accept that. But in respect of the intervention of the National Assembly, that under the Public Protector Act, she reports to Parliament, and there is provision in the Act for the public protector to seek the intervention of the National Assembly in respect of the reports and remedial actions that she makes. And that was submitted to the court in the context where the DA said there was no alternative remedy.
But that says nothing of your admission that a public body is itself obliged to assist or support the public protector in giving effect to the ideals of the Constitution, of the office of the public.
Yes, but the parliamentary process would precisely do that for the public body. If the parliamentary process is followed, the public body is required to account to Parliament. The SABC accounts to Parliament, and so does the Minister. So the process of the Parliament is precisely